I am joined by Louise Plant, Senior Associate in our Health and Safety and Insurances team. And my name is Vanessa Bell, and I'm a partner and head of employment law at Pretty's. So today we're doing things slightly differently in that we're going to spend the next 20 minutes or so talking about managing the return to the workplace with a particular focus on high-risk employees. And then once we've done that, we're actually going to open this webinar up to a legal surgery. So which you would have seen from the invite, we're going to be inviting you to ask questions both related to the topic we're covering today, but also any other employment law or health and safety questions that you may have. And we will see where that takes us. So what I'm going to do is just move to the agenda. So Lou is going to take us through health and safety duties in respect to this extremely vulnerable category. And I am going to be looking at some of the employment considerations that come out of basically what Louise is going to be talking about. So what I'm going to do is I'm going to pass straight over to Louise now to get started looking at health and safety.
Thanks, Vanessa. So as a start off, I'm going to cover what your duties are as a general rule in terms of the Health and Safety at Work Act. And then obviously we're sort of looking at COVID and specifically therefore what your duties are to the higher risk employees that you may have and that you're thinking of getting back to the workplace. And then we're going to be thinking about what you need to do to prepare for them to come back to the workplace, and perhaps what mitigating steps you can take or what you need to consider when you're looking to get those high risk employees back. So as a starting point, Section 2 of the Health and Safety at Work Act, you have a duty as an employer to take all reasonably practicable steps to ensure the health, safety and well-being of your employees. You also have a duty to avoid exposing them to unnecessary risks. The management of health and safety at work regulations requires employers to carry out a risk assessment for vulnerable people in order to assess their working activities and environment. Now, this is not even withstanding COVID. So if you are aware that you have employees who are vulnerable for whatever reason as a result of medical condition or some other reason, then you have a duty to undertake a risk assessment to basically make sure that their job, the workplace, doesn't impact upon that or impacts only, not to any great extent. You have to take into account their vulnerabilities. But in this new COVID pandemic era, what are your further duties? Because the government have now released a list of people that are higher risk. And so what do employers now have to do to take into account these additional risks? At the moment, the guidance is that you need to take all reasonably practicable steps to ensure that those vulnerable people are not placed at further risk. So the general rule is that, or the general guidance is that you need to be taking steps to ensure that your employees are not exposed to, or the risk of being exposed to the transmission of the virus is at the lowest level practicable, the lowest level possible. So who are the people at risk? The government have effectively split people into two categories, or two groups of people who are at higher risk than the rest of us, basically. The first category of people is the clinically extremely vulnerable people who are deemed to be at high risk. Examples of people in this category would be those that are undergoing cancer treatment for various types of cancer. So they're undergoing radiotherapy, or they're having various procedures for cancer, who've had organ transplants, who have perhaps severe lung conditions, and we're talking about people with cystic fibrosis, COPD, or someone who is at risk of getting infections or perhaps have serious heart conditions. Now, those people who are deemed to be clinically extremely vulnerable in all likelihood will have had a letter from their GP, and those people are deemed to be, at the moment, and I'll go on to talk about this in a moment, until the 31st of July as things stand, they're shielding. So they're your clinically extremely vulnerable people at high risk. And the second category of people is employees who might be just deemed to be clinically vulnerable. They're a moderate risk. So if they caught the disease they could perhaps be impacted more than someone who is of full health. Examples of people at moderate risk are those with chronic or mild respiratory diseases, perhaps someone who's asthmatic, chronic heart, liver or kidney disease, someone with diabetes, people who have been deemed to be overweight are at more of a moderate risk, and also people who are deemed to be aged 70 or over are also deemed to be at moderate risk. Someone who's pregnant will also fall into the moderate risk category, but it's worth noting that if that person is pregnant and they have also an underlying health condition, such as a heart condition, then they may actually fall into the high risk category. So you have two groups, or two specific groups, that the government are advising on, who are either clinically extremely vulnerable or clinically vulnerable people. Those who are extremely vulnerable in all likelihood have had a letter from their GP. The other employees, however, that I've added on, and there might be some other circumstances that you need to have a think about in terms of your employees, who also might be at risk, or certainly would have a risk element to either their lifestyle or their circumstances, that mean that you might need to take into account those employees specifically as well. I'm thinking more employees who perhaps live with someone who's has a serious illness, or who may be clinically extremely vulnerable. And those people may also want to take additional steps to protect themselves, so that when they go home, they're not then putting a further risk upon their family members or whoever it is they might be protecting at home. So they're your two groups, or your two main groups of people that you want to be considering in terms of your higher risk employees. So what does the government guidance at the moment say in terms of those two categories in particular? The first category, the high risk, they have been strongly advised to stay at home and keep visits outside to a minimum. So basically, this means that as things stand, and up until the 31st of July, those people should basically not be in the workplace. Employers should support employees to stay at home and to abide by the guidance in those circumstances. However, at the end of this month, shielding is meant to come to an end, or shielding is to be paused, is the wording that the government's using. And what this means is they say that at the moment, you are still shielding. However, from the 31st of July, you should be able to return to the workplace, provided that your workplace is COVID secure. And I'll go on to talk about that in a moment. So from the 1st of August 2020, you can welcome back those higher risk employees back into the workplace, but you need to take steps to protect them. And I'll go on to talk about that in a moment. It's also worth noting that if the transmission of the virus rate increases, then it might be that shielding is then reintroduced for those people at higher risk. It's also worth noting that although shielding comes to an end, that doesn't mean that those employees aren't still at a higher risk. They will still be in the higher risk category. It just means that the shielding position has paused as of the 31st of July. So what happens with regards to people at moderate risk? Well, the guidance for them is still that they follow social distancing, but they should stay at home as much as possible. And if they can't work from home, then employees they are able to attend the workplace, and they can go out for essential activities. Now, when the lockdown was eased in early May and the guidance was reduced, then those people could go back to the workplace, but of course, employees had to take steps to reduce the risk to those employees specifically. So what should employees do when they're considering those perhaps more vulnerable people who are coming back to the workplace, or they want to get back to the workplace? First of all, we'd advise finding out what employees fall into what category. So you know what you're looking at, you know who those employees are that you need to be thinking about. And you can ask them perhaps to complete a questionnaire with regards to whether or not they fall into the clinically extremely vulnerable or just the vulnerable category, or whether they've got some other circumstances that they would wish you as an employer to take into account when thinking about their return back to the workplace. First of all, find out which employers you're going to be looking at. The next thing that you're going to be required to do is to undertake a specific COVID-19 risk assessment for those higher risk employees. Now, I'm sure you're probably all aware, in terms of getting your employees as a general rule back to the office, let alone considering the higher risk employees, you need to undertake a COVID-19 risk assessment to look at your practices and procedures, to make your workplace as safe as possible to get people back into the workplace. Now, with regards to your higher risk employees, you need to be thinking about undertaking a specific risk assessment for those individual higher risk employees. And off the back of that risk assessment, you'll then need to think about what appropriate practices and procedures you can put in place to protect them. The steps that you'll take are going to be very much dependent upon the employee, their capabilities, your business, your working layout, and you're going to have a chat with those employees and liaise with them to try and figure out what steps can be taken. And I'll go on in a second to go through what mitigating practices and procedures you might want to put in place. But I can't emphasize enough the importance of liaising with those employees to have a chat with them about what their risks are, how they do their job, and how perhaps you can take steps to try and reduce the risk to them as far as possible. Now, whether or not you have vulnerabilities, the return to the workplace in the current climate is going to be perhaps a stressful and quite an anxious time for a lot of us, let alone those who are at higher risk. So in order to try and make those employees feel safer about the return to their workplace in this current situation, it really is important that you speak to them and you take on board their concerns and you think about the way that they work and you put in place those practices and procedures and those steps to make them feel that when they come back to the workplace, they're as safe as possibly can be in the situation. So what steps could you take as an employer to protect those employees? Well, at the moment, the guidance is very much still, if you can work from home, then continue to do so. So employers should be providing equipment and keeping in contact with those employees and monitoring their well-being while they're working from home. And that's still the guidance. The next position is with regards to if employees can't work from home, what can you do? Those employees may not be able to work from home either because of the operational needs of their role or because of their home circumstance. It may make it impossible for them to return to work. But again, you want to get them back into the workplace. So what can you be thinking about? Well, could those employees undertake an alternative role that could still allow them to work from home is a first point, in particular where the guidance is still, if you can work from home, then continue to do so. Or if they can't stay at home, then you need to be thinking about the safest available on-site role that they could undertake to enable them to stay 2 meters away from others. What you could think about is looking at their working hours, their workstation layout, whether you could put barriers or screens in between them to protect them from other employees, allow them to work not face-to-face, but side-by-side as opposed to face-to-face, working back-to-back. Thinking about how they move around the workplace, because the guidance is it's 2 meters still, but 1 meter provided that mitigating steps are put in place, which I appreciate can be quite confusing and not clear cut, because the reality for most employers is that the mitigating steps that you can take will vary from business to business, from place to place, dependent upon your layout, the employees that work for you, what resources are available to you, how the workplace is managed and organized. You need to think about how people are coming in and out of the office or the workplace, sorry. You need to think about how they're liaising with other people, contractors, other people coming out on site. And that is going to be very much variable depending upon your workplace. But have a think about that individual's role and what that individual is doing. And then, as I said, liaise with them with regards to what steps you can take to reduce the risk to them to the lowest practicable level. If none of the other options are available and you are concerned that they're returning to the workplace, you can't put in place all of the mitigating steps to reduce the risk to them, and they are a higher risk employee, then I think that the next step to protect yourself and to protect that employee, you're going to have to do a further risk assessment and see whether or not, bearing in mind that individual's specific vulnerabilities and circumstances and your individual business, whether or not the risk to that employee is acceptable. And if it isn't, bearing in mind, again, your business and that employee, you need to think about whether or not, therefore, the return to the workplace is acceptable at all. I appreciate that this is very difficult, and it's very difficult advice to give, and it's hard for employers as a whole when they've got to think about getting the workplace back as a whole, let alone dealing with higher risk employees. But if you go through the guidance and you look at the mitigating steps, hopefully you are then in a position to then have a discussion with those employees so that when they do come back into the workplace, they feel safe, you feel protected as an employer, and that they're able to sort of carry on with their job as best they can and feeling as safe as possible. So I'm going to hand over to Vanessa now, and I think she's going to talk to you about the employment considerations with regards to those higher risk employees. And then at the end of this, we're going to go through the questions that we've had, and we'll respond to them at that point.
Thank you. So I've just got a couple of slides I want to take us through. And the first one is the further amendments to the Statutory Sick Pay Regulations. I'm not going to read out all of that, although the name of the regulations there, because it's quite a long title. So these regulations have amended the SSP regs. So they provide for SSP to be payable where an individual self-isolates because they are in either a linked household or an extended household, or actually what we might recognise as essentially in a bubble, because that terminology is used quite a lot as well. And so it's payable where somebody in your bubble has COVID-19 symptoms. So you may recall that previously SSP was only payable where an individual was actually living in the same household as somebody with symptoms. So now it's just extended it to say if it's somebody within that bubble and obviously you've been in contact with them. SSP will stop being payable if that individual then goes and gets a COVID-19 test and comes back negative. So then the SSP stops. And also remember that an individual is also entitled to SSP under the contact tracing provisions if they've notified as being in close contact with somebody with COVID-19. So that is one part of the amendment, the SSP amendment regs. The other part, which is more relevant to what we're talking about today, is just the changes to entitlement for that extremely vulnerable group who are shielding. So the original regulations provided that SSP entitlement would continue until the end date specified in the individual shielding letter. Well, these latest set of regulations now say that there is greater flexibility, and that original notification, which was in the shielding letter, can be overridden by a further notification to end shielding and for SSP to end. And it also says that additional notifications then may be issued as needed, enabling the individual to start shielding again and be entitled to SSP again. So basically what's happened now is that obviously a number of individuals have got shielding letters, which may have an end date. But what's happened now is that these SSP regulations have come in and they have confirmed that shielding employees' entitlement to SSP is paused after the 31st of July, as of course, as we've explained, extremely vulnerable group no longer advised to shield from the 1st of August. So that category will no longer be entitled to SSP from the 1st of August. But of course, as I said, these regs do have flexibility within them so that this can be restarted again. So in the event that a further notification is sent to an individual to shield later on, then SSP maybe will be reintroduced. And of course, what's happening is that the regulations are anticipating potentially a second wave that may come along, and in that scenario, shielded notifications would go out and SSP would restart again. So that was just to give you just kind of a brief update on SSP entitlement, because I figured it was relevant, especially with the shielding category group. And then I just wanted to spend 5 minutes or so just talking about, as we always do in these webinars, some employment practical issues arising out of the changes that are happening. So one is, of course, employees raising concerns in relation to returning to work. So, and as we said, although from the 1st of August, employees who had been shielding, who can't work from home, are able to return to the workplace, the government has called on employers to kind of ease the transition for clinically extremely vulnerable employees. And as we've mentioned, we need to put in robust measures to enable a return to a COVID-19 secure workplace. And as Louise has touched on, that's going to be quite a high threshold to meet. So you may have employees who say, I do have concerns about coming back into the workplace. I received this letter to say I should shield, and now suddenly I no longer need to shield, but there is still coronavirus around and a lot of it, so I have concerns. So what do we do? Well, of course, the first thing that I would always say is, well, let's listen to the concerns. What are the concerns? And of course, once we know what the concerns are we able to alleviate the concerns? First question you should have with all employees really still at the moment is, can the employee work from home? Because if they can, then that kind of solves the issue. If not, how do we alleviate concerns? Can we make adjustments? So perhaps they work different working hours, so perhaps they don't have to come in. If they come in by public transport, they don't come in rush hour, or just that they're working different hours to colleagues, and so they're not in contact with as many people. Or do we look at redeploying them to another role potentially where they could work from home? So those are some options to consider. Reassure them perhaps in terms of what you have been doing to make your workplace COVID secure. Chat through the risk assessment and the measures that you're taking, see if we can alleviate concerns that way. If an employee is raising genuine concerns in relation to, health and safety and well-being, then we must be careful that they don't suffer a detriment as a result of that. And I'm going to come on to that point a little bit further when I look at refusals in a minute. And so essentially, really, if we get to a point where we're unable to address the concerns, we then perhaps will get employees who refuse to return to work. And so what do we do then? Well, again, first question, can the employee work from home? If they can, then that may well is going to resolve the issue, and they should be working from home. If the employee, because of the particular job that they do, can't work from home, then look at the current public health guidance, because it will update from time to time. And again, learn about the specific reason as to why the employee is concerned about attending work. Then we think, well, okay, actually, we've discussed the concerns with them, we've sought to alleviate them. We actually feel that, it would be safe and secure for them to return to work. Can we then kind of potentially say to them, well, you need to come back to work. Otherwise, we're giving you a reasonable management instruction here to perform your duties. And if you don't do so, we'll consider disciplinary action. Well, before we do that, I think we first have to think about, would it be discriminatory to do so? Are there potential, discriminatory angles here? For example, potential for disability discrimination, perhaps a failure to make reasonable adjustments. We need to think about those things. But if there isn't, if we've kind of got through that hurdle and the public health advice is such that employees can be asked to continue to attend the workplace, then it is possible that you can investigate, the staff member for misconduct in terms of their refusal to follow a reasonable management instruction and unauthorised absence. And of course, in unauthorised absence, the employee is very likely to be not to be entitled to be paid, because unauthorised absence is normally unpaid. However, that is quite a bold step to take, and whilst the guidance is adjusting, and we listen to the government and the politicians urging us to perhaps get back to the workplace, which doesn't always necessarily tally with the guidance that's issued, we do still need to be careful. People are going to be having genuine concerns potentially about returning to work. And we also do need to have a think about also, if they're raising genuine health and safety concerns, and we're potentially looking at dismissing due to unauthorised absence, then, we need to be wary of automatic unfair dismissal claims, because the claim could be, well, you dismissed me because I've raised health and safety concerns. And then we also need to look at the provisions in the Employment Rights Act, which provide additional protection for employees. And there's two sections in particular which have rarely been looked at up until now. They've rarely been argued in tribunals. But there's section 100, which protects dismissals on the grounds of absence from work if the absence was due to a reasonable belief that attending work would put them in a serious and imminent danger. There is no qualifying service needed for that type of claim, so you don't need a 2-year service, and it's also an automatic unfair dismissal claim if the reason for dismissal was due to on the grounds of absence, and the employee can show that they had a reasonable belief that attending work would put them in serious and imminent danger. And we also have Section 44 of the Employment Rights Act, which protects employees from being subjected to a detriment because of their absence, if the absence again was due to a reasonable belief that attending work would put them in serious and imminent danger. Danger has been interpreted broadly in the case law. Of course, it didn't really cover a pandemic. That doesn't cover a pandemic. So 100% don't know whether danger would, but I think it really is kind of quite feasible that you could include the risk of contracting COVID-19 from a colleague or a client as constituting danger. It needs to be a reasonable belief, and it needs to be a reasonable belief of serious and imminent danger. But that's a subjective test, and it's based on the employee's perception. And so in particular, what that means is that just because you may have a group of employees who are happy to return to the workplace, that doesn't mean that an employee refusing to return doesn't have a reasonable belief in that danger. So in conclusion, it's quite a tricky area, actually, employees who are refusing to return. And my advice is always to carefully consider the employee's justification for failing to attend work before deciding what action we want to take. We then have employees with family members who are in the extremely vulnerable category. Again, would home working be a potential solution? Because consider that. The Public Health England shielding guidance, so as at the moment, that guidance says that the rest of your household don't need to shield themselves if you're shielding, but they should do what they can to support you in shielding and carefully follow guidance on staying alert and safe, i.e. social distancing. So the guidance for those that are shielding doesn't expressly require someone living in the same household to stop working or to shield themselves. However, what we would say is, we should be reacting sensitively to genuine concerns that are being raised. As the most, you may want to kind of consider unpaid leave, but I wouldn't necessarily advise going down a disciplinary route, but of course it depends on the circumstances. And as we've discussed, the shielding guidance is going to be paused from the 1st of August, which means it's likely to be harder for an employee to justify a refusal to attend work on the basis that a close relative is shielding. And in terms of potential discrimination, well, we do have discrimination by association. So we have direct discrimination, harassment, and victimisation. These types of claims can be brought in terms of associative discrimination. So what that means is that we just need to ensure that employees don't suffer repercussions because of an association with someone who has a protected characteristic. So the key protected characteristics here would be disability or pregnancy. And I spotted while Louise was talking that somebody has raised a question that is a really good example of what I'm talking about here. So the question was, an employee's wife is undergoing cancer treatment and has been told to shield for 2 weeks prior to and after surgery. Is it reasonable for the employee to shield with their spouse, or could they be asked to return to work? So brilliant question, really timely for me. Thank you very much. The answer to that is, well, we need to kind of listen to the concerns that the employee may raise in terms of returning to work. Can that employee work from home? If they are required to come into the workplace, can we reassure them in terms of the safety measures and the risk assessments that we've done, that it's safe for them to do so? We do have, of course, the potential discrimination angle, just because we know that cancer, for the purposes of the Equality Act, is a disability. So we do have potential for associative discrimination there, direct discrimination, but the employee would need to show that they've been treated less favourably because of their partner's or their wife's discrimination, which could be quite a high hurdle to show. I think really for me the answer to this question would be to consult with the employee, see if there are alternative ways for them to work which make them feel more comfortable. And if they can't return to the workplace, or they refuse to return to the workplace and they can't work from home, what you probably will want to consider is whether you place them on the period of unpaid leave for those 2 weeks prior to and after the surgery. And then I just wanted to quickly talk about pay. What do we do? What do we need to pay employees? And of course, it will all depend on the reason why the employee isn't working. But, you know, for those that have, you know, been contacted through the test and trace, or been told or need to isolate because of someone in a linked household or their household having the symptoms, and of course, the entitlement to SSP may well be entitlement to contractual sick pay, depending on whether you have any and what the criteria is. For those employees that are refusing to return to work or unable, or you accept with them that, you know, it's not safe for them to work, what pay do they receive? Well, we know that for those that are shielding, there's no automatic entitlement to SSP now. Do we place these employees on full pay? Obviously, it's very costly, but it's something to consider. Remember that with pregnant employees in particular, where the nature of their role means they can't work from home and there's no suitable alternative work available that they could do from home, you may need to consider suspending them on full pay, just because pregnant employees do have kind of additional rights. Think about, as I mentioned before, unpaid leave. Say, you know, if somebody who is not comfortable returning to work and you say, well, that, okay, we accept that, it's approved absence, but it's going to be unpaid. Perhaps give them an option of taking some annual leave. Furlough, an option, but only if that employee has been furloughed previously for a period of 3 consecutive weeks prior to the 1st of July. If the employee hasn't been furloughed previously, then we know that we are unable to furlough that employee now. And also, if we are considering the refusal to return to work as unauthorised absence, then it may be, again, unpaid leave. So there are a few options in terms of pay, and obviously the options will depend on the particular scenario that we are facing. And then I've just put on there as a final kind of thought as to be prepared for further lockdowns and the potential for further shielding notifications. And this is just a little bit about just a point of, you know, forward thinking, forward planning, perhaps. You know, are we flexible enough with our IT perhaps to allow the extremely vulnerable category to work from home on short notice? What would we do if there was a local lockdown? You know, what's our contingency plans for those situations? And of course, you know, if we do have a second wave later on, it's very, very unlikely that we will have the furlough scheme to access at that point. So I would just say is just consider and plan for different eventualities now for what may arise, or what will hopefully not arise in the future. So I think we've got a number of questions, one of which I've answered. Louise, I haven't been keeping an eye on them, so do you want to let me know what we want to tackle first?
Yeah, so should we go? We had a couple of emailed ones through before the webinar, so we'll go through those first. So we've got a company of 30 staff, a rented office on a business park with a commercial landlord. Done everything we can to make the offices as COVID secure as possible, but the staff need to access communal areas, which is outside the office, but within the main building. They're not satisfied the landlord has taken all the measures they should have done, and those issues have been raised with them, but to no effect. So is there anything more we can do to put the pressure on or to deal with that situation? Yes, basically. So you've said that you've already raised the issues with the landlord. I think the next step is then to formally, if you haven't already put it down in writing, raise those issues again with the landlord and point out that if they're not taking the situation seriously, then you're going to have to notify the HSE accordingly of the situation and get them involved. And hopefully that should then prompt the landlord to take sufficient steps. The guidance is very clear in that if you do have concerns, whether as an individual within an employee, within an employer, or as another employer working with other landlords on a communal premises, that you can access the HSE for further guidance and for further assistance. And then if need be, the HSE will attend and either issue the landlord with a notice or perhaps even a fine, I would like to think that what they're going to do is that they'll go and issue the landlord with a notice to take appropriate steps if they aren't taking sufficient measures to make sure that they're COVID secure, where they've got members of the public in particular accessing the property. So yes, if you say you've already raised the queries, raise them formally and point out that if they don't do something about the situation, then you'll notify the HSE accordingly, and hopefully that should be enough to then prompt them into action. The next question we've got, you've got a company who most of the staff been working at home acceptably, and this is something that's been raised time and time again recently from a number of people that I've spoken to. But you've now got situations where you've got significantly reduced productivity because of people working from home. And this is kind of a crossover between both me and Vanessa. You want staff to go back into the workplace. You've done the full risk assessment. You've done everything you need to do to be COVID secure. But the staff are quite rightly saying, guidance says we should work from home. Well, how do we deal with that? So I think where you've got, and you'll have to correct me if I'm wrong, Vanessa, they're correct in that the guidance says if you can work from home, then do so. But if you're seeing that productivity has been impacted as a result of people working from home, then I think, and as I said, Vanessa, if you don't mind taking over in a second, whether it's to do with productivity and they're not performing properly, then that's a performance-related matter. Am I right?
Sorry, I was on mute, so I wasn't talking, and nobody would have heard, including you that time. Yes, I think it's a difficult one, isn't it? Is it productivity because actually the employees are perhaps not working as hard at home as they would be in the office? And we can all use our imaginations to figure out what employees might be doing with their time. But that is certainly a performance issue. If it's a productivity issue just because of the nature of the role, and although we have the IT in place, it's just perhaps clunky and it's just harder to effectively do your job, then it's not so much of a performance issue. It's just kind of a situation where, unfortunately, working from home just generally is not as productive for the business as it would be in the office. And I think, the questions are and the points we raised is a really good one, in that, there are a number of employees who, have quite happily settled into working from home, enjoying spending more family time, enjoying not having the commute, perhaps enjoying the ability, if they have a high pressure role, to kind of get their head down and not have constant interruptions and think, oh no, actually, I feel I'm more productive at home. So, it is, and we do feel like the general consensus sometimes is that actually what's going to happen is that there's a number of staff in the UK that are going to turn around and go, actually, I want to work from home more. But I think critically, it has to work for the business, doesn't it? And, if all your staff working from home isn't going to be conducive with, a profitable business, then we're going to have to say, well, unfortunately, we can't accommodate permanent working from home. We're listening to you, but unfortunately, we can't. What you might want to do is perhaps look at achieving a middle ground where you have staff working from home part of the week and then in the office another part of the week. But it's an interesting one. But just because an employee suddenly decides it's far more convenient for them to work from home doesn't mean that they have the right to. What I have heard rumours of, and this is rumours, so don't quote me on this in several months' time, but I have heard rumours that, there are kind of some lobbying for actually legislation to be introduced to allow employees to work from home if they want to. How employees have the right to kind of make flexible working requests, might be akin to something like right to request to work from home. And that would obviously increase the burden on an employer when considering working from home requests. But so we can watch the space on that one. Some are saying they want to introduce a right to be able to work from home, and that would put a whole new spin on things. But at the moment, if it is just kind of a preference because it's more convenient to work from home, then no, I don't think we need to necessarily, we don't need to be going back. So yes, that's fine. We'll bend over and accommodate that. And I think the person who raised the Actually, do you have anything else to add on that before I move on?
No, I think that's right. No, that's right.
And the person who raised that question made a comment which is actually pretty much identical to a question that we've received. I'm sorry, I'm going to make this really difficult for us because I'm hopping between questions here. But Boris on Friday said, go back to work if you can, yet the public health guidance still is work at home. Will it change to reflect government advice? Well, you kind of hope so, wouldn't you? But I think we have all been tearing our hair out this week, because as soon as I saw and heard Boris, I immediately went onto the website with this webinar obviously in mind as well, but to see if there was an update to the guidance, and there hasn't been.
No.
And I mean, obviously we understand why. Well, you know, obviously he's saying it in terms of boost to the economy, and he probably looks around the city and opened up hospitality and all sorts, and nobody's out at lunchtime buying their sandwiches. So there's obviously the economic drive behind those statements at the weekend, but at the end of the day, they haven't actually changed the official guidance, have they?
No. But I think I hope that it's changed to reflect that, because it's so hard for employers at the moment where the guidance is work from home. But as we sort of touched on earlier, if your productivity levels are dropping, and we're hearing this from a number of different employers at the moment and their concerns, then I think Vanessa's right in terms of thinking about alternative solutions, getting people back into the workplace and using their personal situation at home. There's two reasons that people can return to the workplace at the moment in accordance with the guidance. One, if their role means that operationally they need to be back in the workplace, or two, if their home circumstances are such that they can't. So it might be perhaps that you use the second limb to say, well, if your home circumstances are such that you're not productive at home, then perhaps we'll look at getting you back into the office. But the guidance needs to change. Because it is completely conflicted at the moment. I appreciate that. It's a hard task for employers to get that balance right.
Yeah, it is, isn't it? So just looking at some other questions that we've received, and at the moment they all kind of relate to what we're talking about, but I'm just looking at the time. If you do have any questions that are not specifically about what we're talking about today, but are employment or health and safety related, then do ask them, because we did promise to open it up to legal surgery, so I do want to fulfill that promise. But if they're all related to this, that's perfect. It makes it probably far easier for us, doesn't it? Question we've got: what do you do if employee risk is not acceptable? Furlough ? Pay sick pay ? Full pay ? Well, I think I've kind of covered the pay point previously, but I think there is a distinction I probably would like to make now, and that's if as an employer we're saying we can't have you back because we can't open up the workplace because either there's a local lockdown or because actually we just can't put measures in place to make it safe, full stop, and you can't work from home, then we go back to the kind of original position as to what many employers kind of faced back in March is, well, actually, if we've got our employees who are ready and willing to work and it's us who can't actually allow them into work, then those employees would be entitled to full pay. But if the reason for an employee not attending work is due to kind of what we've been talking about today in terms of, you know, they're refusing to work or got concerns, even though we're saying to them, well, you can work from home, or, you know, we feel it is safe for you to return because we've done, you know, all of this and we've done our risk assessment and we're confident and comfortable. And it's the employee who doesn't want to come to work, well, then they're not ready and willing to work. And therefore, that's when we start looking at the other options of, you know, can we put them on furlough? Are they entitled to SSP? Are they entitled to sick pay? Or are they going to be unpaid? So hopefully that helps answer the question in terms of pay there. Another question we've got, which I think is one for you, Louise. In the absence of health and safety workplace representatives, do you need to consult with everyone individually on the measures put in place for returning to the workplace?
The guidance basically says yes, to some extent. What I would advise you to do is that you've done your risk assessment, and the advice is and the guidance is, and I'll explain the reasoning behind it actually, which does make sense. That part of the guidance makes sense, in that you do your risk assessment and you consider all the risks to your business and consider the risks to the employees in terms of the way that they work and the layout of the workplace. So you've got your risk assessment that's identified where the hazards are, where the risks are. And off the back of that, you then put into place what steps you're going to take to try and reduce that risk. And whether it's staggering people coming into the office, different entry and exit points, moving the layout of the office about, or, you know, cutting off communal areas, whatever those steps are. Once you've done that and you've got that document in place, you then send that to your employees and you say, look, what do you think, basically? And to some extent, you're going to be opening it up to them to raise their issues and to make their comments. But the reason being, again, it goes back to the point that what you want to do is, where you're getting employees back into the workplace in this pandemic situation where they're going to be anxious, they're going to have concerns, getting them involved will assist them to feel safe. So when they do return, that anxiety or that stress is reduced. And also, as the employer and as the employees, you're the ones that are going to be knowing what's going to work and what isn't. And if you've suggested some steps and the employees are saying, well, do you know what, that's just not going to work at all for me, then take that on board, amend the risk assessment, amend the steps and procedures. And it is meant to be a very collaborative approach to it, and that the employer sort of says these are the proposals, and engage with your employees to make sure that it can work. Because the idea is that you want people back into the workplace, you want everyone to be happy and not anxious. So, you know, cut to the chase. Yes, engage with everyone individually or as a group of your employees, send it out to them and get them to comment, and also get them on board so that when you do sort of come back to the workplace and you are doing that, everyone's happy and they're happy that the risk to them has been reduced. So I hope that explains that one.
Thank you. Another question we've got, which I think is for me, what about if an employee has to look after dependents and can't come back to work? And that obviously is still quite a key issue for many staff members, because whilst some employees may have been lucky enough to have their children return to school, depending on the year groups, we now come back to summer holidays. I'm speaking from experience here. And, you know, it's a juggle, isn't it? And it is hard. And it's hard for the employer and it's hard for the employee, because the employee needs to look after their children. Not all summer holiday clubs are open. If they rely on grandparents, the children to look after them, then there may still be concerns that they don't want to put the grandparents at that risk. So if somebody says, I can't, you know, I can't work because I need to look after a dependent, do we, you know, one thing is we could talk to them about, well, if we were to change their hours, would that assist them to perform their duties? Do they feel they'll be able to, if they can work from home, do they feel they'll be able to juggle working from home with childcare? Do we look at potentially agreeing a short-term kind of adjustment to their hours, so they reduce their hours so they can better juggle it? So it's kind of like a dialogue with an employee. If, you know, none of those are kind of viable options for you or for the employee, then we will fall back onto this right, which is for time off to care for a dependent, and that time off is unpaid. So what you would be saying to the employee is that, you know, in accordance with the regulations, you can have a period of unpaid leave to take time to look after your dependents, but that will be unpaid. And that's what I suggest that you would do in that situation. I've got some furlough questions. Can we claim statutory notice pay through the coronavirus job retention scheme whilst an employee is furloughed, or should we just pay the statutory notice pay? This has been a question that has caused us, a couple of sleepless nights, if you may, but just generally lots of discussion amongst barristers, solicitors and such forth. Our view right at the beginning was that actually, you know, there's nothing in the scheme that prevents an employee serving their notice and claiming furlough pay, an employer claiming furlough pay. And that seemed to be the general understanding amongst us lawyers. Very recently, when the most recent Treasury direction came out, it had an amendment in it, and it said, I can't quote it for word, but it had something in there about, you can only access the scheme if it's retain or keep the employee in employment. And so then it raised the whole question about notice again, because of course notice is when somebody is due to leave, and we're not actually using the scheme to retain the employee. However, when I looked at the guidance this morning, there is now a line in there that explicitly says that I've got it because I looked at it this morning. You can continue to claim for a furloughed employee who is serving their statutory notice period. However, grants cannot be used to substitute redundancy payment. So the answer to your question now, Joanna, is yes. You can continue to claim. You can claim the statutory notice pay through the scheme, which I think for many of us may well be a relief if we're looking at making redundancies at the moment. Next question on furlough. If we move somebody from furlough to flexible furlough, can we then put them back on full furlough with the agreement, of course? Yes, you can. Quick answer to that one. From 1st of July, it really is a flexible scheme. So you can have somebody who has been on furlough and you put them on flexible furlough for, say, working a couple of days a week for a month, and then you decide that actually you need to put them back on full furlough. If you've got the agreement, yes, you can do that. No restrictions. There's another one, isn't there?
How long can an employee take time off work without pay?
I guess if that question is in the context of the time off for dependents, the time off for dependents is essentially only there for a reasonable period of time to put in place alternative care. So before this COVID-19 pandemic, it was really only used if perhaps a child turned sick, and it was only really there for a reasonable period of time, say a couple of days, for either to look after the child or for the parent to sort out alternative care for the child. I think what's happening at the moment is that this is used a bit more in terms of the context of COVID-19 and everybody struggling and everybody kind of putting in together, that actually you might have more prolonged periods of unpaid leave in that scenario of caring for dependents, because certainly up until very recently it was very hard to find kind of alternative kind of care providers. So time off for dependents is only really meant to be for a reasonable period to enable you to sort out alternative care. Generally speaking, if it's because we're talking about unpaid leave because somebody's refusing to come to work or doesn't feel comfortable coming to work, we've just reached an agreement with them that they can be unpaid leave because, say take the earlier example about, and it might be the same person asking the question about, if the wife's having cancer treatment and shielding for a couple of weeks and the partner wants to kind of stay off work, then it's just up to you to agree it with the employee. So just reach an agreement that there will be a period of time that will be unpaid leave. And if you feel that the employees want to take longer than is reasonable, then, and that's when you kind of have a discussion, say, well, we give you this period of unpaid leave up until this date, but after this, we really need you to return to work. And then that's when we look at potential, this is a reasonable management request, a reasonable management instruction, and there might be repercussions if you don't return. But essentially, it depends on the circumstances and it depends on what you want to agree with the employee.
I think that's...
There's no more questions at the moment, isn't there?
No, I think there's someone else is typing, but I'm not sure if it's a question or not.
So we'll leave it for a minute. And we'll just see if we have any other questions. It was sometimes, oh no, so it sometimes teases us. Oh no, here we go. Sorry, another furlough. Oh, another furlough. If we have to pay accrued holidays, can that be part of a furlough claim? Yes and no. They're going to love me for that answer. Yes and no, aren't they? If you pay in lieu of the holiday, so say there's termination and you're paying in lieu of holiday that hasn't been taken, then no, you can't claim it. If you designate holiday days throughout the furlough period and say, for example, I want employer me, I'm giving you notice to take a week's leave and I'm giving you 2 weeks notice to take a week's leave and these are the dates of your holiday, then yes, you can claim it through furlough because they'll be taking holiday during the furlough period. However, remember that for holiday, you have to top it up to 100%. So you can claim the furlough grant from the CJS scheme and then you have to top it up by the 20% or the 30%, or depending on what months we are coming up, so that the employer receives 100% pay. Okay, furlough and a holiday question together in one question.
Lucky you.
I know. So I think that's probably it. So thank you everybody for all of your questions. It was, as I said, it's a trial. It was a trial one today, wasn't it? To kind of have a topic for 30 minutes and then open it up for questions. If you're able to provide some feedback, and thank you for the comments that you're providing now, but if you're able to provide some feedback immediately after you close the webinar, there's a facility to do so, particularly if you found the legal surgery helpful or not, because that will obviously help guide us as to whether we do it again or not. And we will also be sending out a briefing note, I think tomorrow, all being well, which will give you some further information on the topic that we've been talking about first thing this afternoon. But otherwise, all I wanted to say is thank you very, very much for joining us this afternoon. And goodbye. Thank you.